Everything's Fine on 93.9 Dublin South FM.
Thank you. Today we are going to discuss a critical issue that could alter the course of Indian democracy. But then a disclaimer here at the outset, we want to clarify that we do not support or oppose any political party. Instead, our primary concern is India's interest, and we raise issues that matter most to the nation. We deeply value our hard-fought independence and freedom from the colonial rule, and under no circumstance we wish to see anyone dilute or restrict those freedoms, that freedom which is enshrined in the Constitution of the country. With this spirit of vigilance, we will discuss today's topic. In 2023, the government passed the Digital Personal Data Protection Act. At the time, some concerns were raised, but they were largely overshadowed by other pressing issues, including the violence in Manipur. Now that the bill has been enacted, the government is set to notify its implementation sometime in April this year, along with rules and regulations. So, according to the government, the law aims to protect Indians from data breaches, prevent the misuse of personal information, and uphold the right to privacy. The government asserts that it seeks to safeguard the data of Indian citizens. With the rise of social media and e-commerce platform we all use every day, companies, tech giants, collect and process vast amount of data such as names, addresses, age, preferences, and they do so to target consumers and consumer behaviors effectively and to make profit. Major corporations like Facebook, Google, Twitter, now called X, they store this information in their servers which are located outside India, which means that the data of you and me, of all the Indian users, is controlled by these foreign entities. And that is where things get complicated. However, the new law has faced strong opposition due to concerns about its potential hidden agenda. Before going deeper into the complicated matters, it is important to understand the significance of the Right to Information Act. Now, this was introduced in 2005 by the previous government, and this Right to Information Act, RTI as we all know, empowered Indian citizens with the fundamental right to question authorities, demand transparency, and hold those in power accountable for their actions. Over time, now it has been 20 years, RTI has played a crucial role in upholding the spirit of democracy in India. There have been numerous examples, I'll come to them. Regardless of which government was in power, authorities are often exposed through RTI inquiries. Many voters have got dismayed and the elections have changed results. Perhaps for this reason, in 2019, the current government, it curtailed RTI's effectiveness by weakening the secure tenure of the Chief Information Commissioners. Now, previously, these officials had a fixed tenure of 5 years or until the age of 65, like any other constitutional heads, like Chief Justice and Election Commissioners. And the Information Commissioners were drawing a salary equivalent to Election Commissioners of India. However, the government altered this provision, making their tenure subject to its discretion. As a result, what happened is, information commissioners are now effectively dependent on the central government, and this raises concern about their autonomy and a concern raised by Justice Sri Krishna. So it is just not up in the air that people are worried about. In a continuous effort to weaken RTI as alleged, or we can suspect, the government introduced an amendment to a crucial section of RTI Act, and that section is called 8 subsection 1 subsection J. Now, this section previously allowed the disclosure of the names if the information of the public interest and relevance. Because of this provision about the public interest, RTI helped expose corruption scandals such as electoral bonds, which is a major one, and the massive bank write-offs favoring the wealthy and the powerful. Now, the journalists and the press were able to identify the corporations and the individuals involved in crony capitalism and favoritism, and this transparency actually brought accountability to the government and exposed conflict of interest. Probably the electoral bonds were one of the factors for the ruling BJP to not secure a majority on its own in 2024 elections. Such is the power of RTI. However, such revelations have embarrassed the ruling establishment even if they are opposition ruling the states. Now, under the guise of this Data Protection and Privacy Act, new legal restrictions will make it harder to name companies and individuals involved in the wrongdoing. So under the new law, journalists, university researchers, civil society organizations, including our resident welfare associations, RWAs, and political parties, they will be classified as fiduciaries, making them responsible for data ownership and processing. They need explicit consent from the individuals or the companies before collecting and publishing the data. Subsequently, failure to comply could result in fines up to rupees 250 crores, and this penalty can potentially rise to 500 crore. Imagine an individual in breach of this act. Although the government claims that the law aims to protect Indian citizens' data, these large tech giants like Google and Facebook, they will remain unaffected. These companies already obtain consent when the user, like you and me, when we sign up for the services of the Facebook, Google, and the WhatsApp. Since users must accept the terms of this platform when we are signing in, we have no choice but to consent. And as a result, these multinational corporations are shielded from this Indian law. Therefore, this raises a critical question. Who is truly at risk of this law? Is it being used to target RTI activists, transparency advocates, or investigative journalists? The Data Protection Act appears to pose a significant threat to those seeking to uphold the government accountable. Some argue that it weaponizes the law and using legal mechanism to intimidate and suppress dissent. Now, this RTI was established to combat corruption and prevent abuse of power. These were the two objectives. However, with dilution of RTI and introduction of this Data Protection Act, the ability for anyone to expose wrongdoers is severely compromised, as you can see. For instance, if the disclosure of the electoral bond transactions had not revealed the names of donors and beneficiaries, Indian democracy would have suffered from lack of transparency. We would have voted for people who were not helping India. Similarly, if banks had been allowed to conceal the identities of the defaulters who fled the country after taking massive loans, the public would never have known how much taxpayer money is lost. At the grassroots level also, millions of RTI applications related to essential public services like ration cards, pensions, scholarships, and even electoral rolls, they help the transparency and the democracy in this country. In recent elections in Maharashtra and Delhi, concerns are raised about voters' list manipulation. With the new law in place, the investigation of these discrepancies will become nearly impossible. This, as a consequence, direct consequence, will weaken the Indian democracy. If political parties cannot analyze voter list due to privacy restrictions, how can electoral fraud be uncovered and prevented? Tell me. Under this law, a regulatory body will be appointed by the government who will determine who falls under the purview of data protection. That's another twist and turn in this act. This means the governing board of the data protection will have the authority to selectively permit or prohibit the collection and the processing of the data. In a democracy, people hold the government accountable through fundamental rights like RTI and freedom of expression. However, with this law, the government will hold individuals accountable for accessing and sharing information while restricting their ability to express what they have been able to investigate and discover. This is not the first time a government agency has been accused of losing its autonomy. Like the Supreme Court once described the Central Bureau of Investigation as a caged parrot. And similar concerns have been raised about Enforcement Directorate, if you remember. So, what is the real motive what is the real intent behind this legislation? We come back to this question again. From the evidence, it appears that the government is not only shielding wrongdoers, allegedly, but also instilling fear, sort of legal terrorism, through disproportionately high fines up to 500 crores, which can be administered by a regulatory body, a data protection board, with an unchecked discretion or being captive of the government. Now, this law marks the beginning of a surveillance state, I fear so, where directly two constitutional rights, the right to information and right to freedom of expression, are being systematically undermined. I strongly recommend reading George Orwell's book 1984, which explores the dangers of a surveillance state and how governments seek to control citizens' right through citizen data. Now, what's the solution? As of now, the immediate solution is that the government must engage with civil society organizations, opposition parties, intellectuals, and the Joint Parliamentary Committee reports to ensure a fair and balanced implementation of this law. If this act is enforced unilaterally, as it seems to be, India risks straying into its democratic ideals. The constitution may be under threat. As the saying goes, they all take the tram of democracy only to reach the destination of dictatorship. Let us ensure that this tram journey from democracy to dictatorship does not become India's reality. Let us ensure that this law does not become India's reality. With those thoughts, I leave you until next week. Keep safe, keep informed, and dutifully ask questions. Bye for now.
Everything's Fine on 93.9 Dublin South FM.